Hello and welcome to Bar 10, where we help you prepare for the bar exam 10 questions at a time. We upload content every day, so please subscribe and ring the notification bell so that we can notify you every time we upload new content. Let's get started with our first question. Husband and wife lived together. Husband was abusive over many years, especially when he became drunk. On prior occasions when husband was drunk, wife would suffer significant injuries and require hospitalization. On this day, husband arrived slurring his speech and having trouble opening the front door. Wife took these as signs of intoxication and further locked the door and grabbed an unloaded revolver, loaded it, and waited. As husband broke the door down, wife shot, killing husband. At the conclusion of trial, defense sought to introduce a jury instruction of self-defense. Should the judge allow this instruction? We have four options as possible answers. Option letter A. The judge should not allow the instruction because wife used excessive force. Option letter B. The judge should not allow the answer if defendant did not show she was in imminent danger. Option letter C. The judge should allow the instruction as this is a question for the trier of fact. Option letter D. The judge should allow the instruction as the defense is in fact making a claim of self-defense. You have 10 seconds to choose the right answer. If you chose option C, you'd be correct. The judge should allow the instruction as this is a question for the trier of fact. Let's very quickly look at the three other options. Option A. It seems as if the judge, in determining that there was excessive force, is in fact making a decision of fact, which he should not be doing. Option B. Judge should not allow the answer if the defendant did not show she was in imminent danger. The answer would seemingly be irrelevant, as generally in criminal matters there is no answer. That's a pleading, which usually occurs at the commencement of civil matters, not at the very end at a trial. Finally, D. Allow the instruction as the defense is in fact making a claim of self-defense. This reads to me as judge should allow it because the defense says so. I don't think too many judges would buy that sort of logic. Let's move on to question number 2. A former Navy SEAL maintained a training facility for retired military officers to ensure they keep their skills to a high level. This included having munitions and guard dogs. The neighbors did not like the former Navy SEAL due to the savage nature of the guard dogs, and especially the mail carrier, whom the dogs regularly tried to bite through the fence as he delivered mail into a box on the outside of the premises below a clearly marked "Beware of Dogs" sign. On this day, Carrier dropped his non-work issued cell phone into the property of SEAL and climbed over the fence to get it. He was promptly attacked by the dogs, although he had no intention of breaking in or committing a crime on the property. Discuss SEAL's liability to Carrier. We have four options as possible answers. A duty is owed to Carrier as he was a daily visitor to the property and it could be assumed he would have to enter the property on occasion. B. No duty. The carrier was trespassing. C. Carrier is a de facto invitee onto the land and as such a duty is owed to him to protect by SEAL. Finally, option D. No duty, as such no liability. Carrier was on notice of the danger and in proceeding assumed the risk. You have 10 seconds to answer this question. If you chose option D, you'd be correct. There's no duty and as such there's no liability. The carrier was on notice of the danger and in proceeding assumed the risk. Clearly the carrier was completely aware of the risk, as it's mentioned that the dogs regularly tried to bite him on a daily basis. So climbing over the fence and landing on the side of the fence where the dogs were probably wasn't the best of ideas. Let's look at the three other options. A. Duty is owed as Carrier was a daily visitor to the property and it could be assumed he would have to enter the property on occasion. This would seem to be inaccurate given the fact that there's a fence, the mailbox is on the outside of that fence, and there are savage dogs on the property. So all those facts point to the carrier is likely not going to be going on to these premises to deliver anything. Option B, no duty, carrier was trespassing. This is an inaccurate statement, as even though an individual is trespassing, a duty could still be owed to that individual. So simply because he was trespassing does not mean that there would be no duty owed to him. Finally, option C, carrier is a de facto invitee onto the land, and as such, a duty is owed to him to protect by seal. Based on the answer A, we could argue that there is no de facto invitee situation here, as in fact it would seem that seal tried to keep carrier out as well as he did everyone else. So as a result, there is no argument to be made here for the fact that carrier was an invitee onto the property. Question number 3. State A, to cut costs, decides to implement a residency requirement for attending local public schools for children. The idea solely being to cut the number of teachers necessary, ergo cutting the costs to maintain schools. Which description best describes the constitutionality of that decision? Option A, the requirement would be violative of the Privileges and Immunities Clause of the 14th Amendment. Option B, this could be argued to be racially motivated if more minority students were kept out of school. Option C, public education is a fundamentally guaranteed right, and the aggrieved parties would have the right to sue for inclusion and/or damages. Option D, this is violative of a fundamental right and as such would be subject to strict scrutiny. You have 10 seconds to choose the best answer. If you chose A, you'd be correct. The requirement would be violative of the Privileges and Immunities Clause of the 14th Amendment. Option B would be incorrect. It states this could be argued to be racially motivated. There are no facts in the fact pattern noting racial differences or racial motivations. So let us not assume things that are not directly within the fact pattern. C, public education is fundamentally guaranteed right, and the aggrieved parties would have the right to sue for inclusion and/or damages. While that may be accurate, that is without question not the best option within the four. And finally, this is violative of a fundamental right and as such would be subject to strict scrutiny. Education does not fall into the strict scrutiny test, and as a result, D would be wholly incorrect. Let's move on to question number 4. Sam drove his car onto a train track. His car was hit by an oncoming train. After suing for injury and damages, a person who resides near the location of the track was called to testify. They did not witness this particular event. How then can they be presented, and in what capacity, as a witness? Option A, to present an evidence of routine practice which may be drawn from such a witness. B, the witness can testify as to their belief in the underlying incident into the evidence. C, the information cannot be used as it does not meet the requirements for an exception to hearsay. Option D, the evidence cannot be used as it requires an opinion from a non-expert witness. Take 10 seconds and see if you can figure this out. Correct answer is A. Evidence of a routine practice may be drawn from this witness. Option B, the witness can testify as to their belief in the underlying incident into the evidence is incorrect. The witness's belief would be completely irrelevant and not admissible as evidence. C, the information cannot be used as it does not meet the requirements for an exception to hearsay. Here, this is not hearsay evidence, as it is in essence an opinion, or as noted in option A, evidence of a routine practice. Option D, the evidence cannot be used as it requires an opinion from a non-expert witness. Here, this answer is assuming that only expert witnesses can give opinion testimony. While this is generally accurate, there are, without question, exceptions where non-expert witnesses can also testify as to their opinion. Let's move on to question number 5. Person from State AA filed suit against a company incorporated in State BB for breach of contract as a result of failing to deliver goods promised under contract. Defendant is incorporated in State CC and has a principal place of business in BB. Defendant moves to change venue to federal district court. What will be the likely outcome? A, it depends on the notice of removal and if it was filed. B, the case will not be removed as defendant is a citizen of state B. C, the matter will be removed as the parties are from different states as to trigger diversity jurisdiction. And option D, it will be removed because the defendant is a citizen of both states. Take 10 seconds to see if you can figure this one out. Correct answer is B. The case will not be removed as defendant is a citizen of state B. Please recall that the corporation is a citizen of both where it is incorporated as well where its principal place of business is. Question number 6. Police pulled Ginny over. She is exhibiting signs of being intoxicated. As they approach the vehicle, they immediately notice a handgun in the rear of the vehicle and ask Ginny to step out of the vehicle, ultimately arresting her for possession of an unregistered firearm. At trial, which statement is likely the most true? A, Ginny did not consent to search the vehicle. As such, the gun will likely not come into evidence. B, plain sight rule is not applicable here if the stop were determined to have been improper. C, Ginny's best defense would likely be it is not her gun but instead her boyfriend's gun, which she knows him to regularly carry illegally. He must have dropped the gun in her car when he borrowed it just before the party which she was going to attend. D, plain sight doctrine applies and it is likely a valid arrest, especially if it can be shown that Ginny exhibited signs of intoxication which affected her behavior and were the cause of erratic driving. Take 10 seconds to see if you can figure this one out. The correct answer here is D. Plain sight doctrine applies and it is likely a valid arrest, especially if it can be shown that Ginny exhibited signs of intoxication which affected her behavior and were the cause of erratic driving. Let's look at question number 7. Boy 1 suggested to Boy 2 that they take an item from Boy 3's home. Boy 2 agrees, but secretly is angry with Boy 1 and decides to set him up. He arrives at Boy 3's home at the agreed upon time, but unbeknownst to Boy 1, he arrives with police who are in hiding awaiting the crime to occur. Boy 1 enters the premises and is arrested as he removes the item from Boy 3's home. All occupants in the residence are asleep and do not wake up until after the police have taken Boy 1 into custody. Which crime is Boy 2 guilty of? A, no crime. B, conspiracy. C, entrapment. D, robbery. Take 10 seconds and figure this one out. The correct answer is A, no crime. Boy 2, in fact, never agrees with Boy 1 to commit any crime. His idea being that he's simply seeking to trick or trap Boy 1 as a result of whatever reason he's angry for him for. As a result, option B, conspiracy, is not a viable option as there's never a meeting of the minds between the two parties. Option C, entrapment, is in fact not a crime, so as a result could not be accurate. And option D, robbery, Boy 2 never in fact enters the premises, so as a result it's not possible for him to meet that element of robbery. Let's look at question number 8. Woman borrowed $800,000 from a bank to purchase a farm. A few years later, woman now owed $750,000 on the farm and decided to sell. She sold for $900,000, which she received $150,000 in cash, and the purchaser assumed the remaining debt of $750,000. Based on this transfer, the bank removed the woman from any personal liability after accepting the transfer and not enforcing their optional due on sale clause. Several years later, purchaser fails to make several payments and defaults on the loan. The property was sold at auction, and upon sale, $100,000 was still owed on the mortgage. Is purchaser liable? A, no, because he was not on the original mortgage. B, no, because the bank released the woman, which thereby released the purchaser from liability. C, yes, the purchaser is liable as he is in essence assumed the prior mortgage and the release of the woman did not affect his obligation. D, yes, purchaser is liable under a theory of unjust enrichment. Take 10 seconds and see what you think is the best answer here. correct answer is C. Yes, purchaser is liable as he has in essence assumed the prior mortgage and the release of the woman did not affect his obligation. Let's go through A, B, and D. A, no, because he was not on the original mortgage. The fact that he is not on the original mortgage is irrelevant because there are generally and can be transfers of responsibilities and transfers of duty within most contracts. Option B, no, because the bank released the woman, which thereby released the purchaser from liability. They are not one and the same. They're in fact two different individuals. As a result, release of one does not mean release of the other. And finally, D, yes, purchaser is liable under a theory of unjust enrichment. It sure seems like he's not enriched. It sure seems like he's owing $100,000, so I'm not certain that a theory of unjust enrichment would be viable or even reasonable. Question number 9. A novelty store purchased 5,000 bumper stickers that were to read Trump/Pence exclamation point, but instead were delivered 5,000 bumper stickers that read Trump/Pence question mark. Novelty store owner noted the difference and refused to pay on the contract. If seller pressed forward with litigation, what would be the likely outcome? A, the contract would be enforced and delivery would be deemed valid as the minor typo did not affect the message in any significant way. It would be deemed full performance on the contract by seller. B, the contract would be enforced. However, seller would be forced to reissue the bumper stickers with the correct punctuation. C, novelty store would not be forced to purchase the stickers if they did not want to, but they may assume the contract under the new terms if they wish to accept delivery. D, novelty store would have to repurchase the stickers from somewhere else after receiving a refund of its fees minus whatever deposit was agreed upon. 10 seconds to answer. The correct answer is C. Novelty store would not be forced to purchase the stickers if they did not want to, but they may assume the contract under the new terms if they wish to accept delivery. Let's look at options A, B, and D once again to see why they're incorrect. A, the contract would be enforced and delivery would be deemed valid as the minor typo did not affect the message in any significant way. Arguably, that is wholly incorrect. The exclamation as opposed to the question mark in essence makes the message extremely different. Option B, the contract would be enforced. However, seller would be forced to reissue the bumper stickers with the correct punctuation. This might be an option, but ultimately the purchaser would have to agree to pay. So ultimately that would be the first thing you'd want to address. So C would be more accurate and more correct because it addresses that issue as the primary issue. D, novelty store would have to repurchase the stickers from somewhere else after receiving a refund of its fees minus whatever deposit was agreed upon. This answer assumes significant amount of facts that are just simply not within the fact pattern. You'll always find answers that do so. Generally, these can be eliminated right off the bat and are generally incorrect. Let's look at question number 10, the last question in this grouping. Robert owns a home and is charged with the sale of narcotics in that home by city police. He is subsequently convicted under a state statute which permits the destruction of properties where narcotics are sold. City destroys home. Robert's family files suit under a different state statute for payment of rent on a new home which they had to secure based on the destruction of their prior home by city. In its findings, the trial court held that under the 14th Amendment, the state was responsible for covering the rental costs of the family due to the destruction of the property. Defendant in the above matter filed for a writ of certiorari in the U.S. Supreme Court. Does the court have jurisdiction? Which do you think is the best answer? A, yes, because the state court based its decision on federal law. B, yes, because federal and state issues are completely intertwined with no ability to distinguish one from the other. C, no, because a decision from the state's highest court renders this application moot. And D, no, because the state is its own sovereign under the separate sovereigns theory. You have 10 seconds to choose the best answer. The best answer here would be A, yes, because the Supreme Court based its decision on federal law. Obviously, as the fact pattern states, the decision was based on the 14th Amendment. B would be incorrect because, yes, because federal and state issues are completely intertwined with no ability to distinguish one from the other, that is not a valid basis for jurisdiction. A would be more correct, the fact that the decision was based on federal law. C would be incorrect. No, because a decision from the state's highest court renders this application moot. C is incorrect simply because generally the trial court is not the highest court in the state. So it's not relevant here, as there was no decision at the state highest court based on the facts in this question. D, no, because the state is its own sovereign under the separate sovereigns theory. This is an answer that appears regularly on bar exam questions, and in all honesty, I've never seen it be correct. The separate sovereigns theory is generally something that can be eliminated right off the bat as well. Thank you for listening on day 1, lesson 1 of Bar 10's bar prep. We look forward to working with you every single day from this point on. And as I noted before, please ring the notification bell as well as subscribe so that you can be updated every time we upload new content.